All right, good morning, everybody. Welcome to the First District Court of Appeals. We have three cases on the docket to be argued this morning. The first case is Walls versus Durrani. Mr. Williamson is here on behalf of appellant. Mr. Winter is here on behalf of appellees. Mr. Williamson, would you like to reserve any of your 15 minutes in time for rebuttal?
Well, I'm assuming that you won't let me reserve all 15, so I'll go with 3 if you don't mind.
You can reserve all 15, but then Mr. Winter probably wouldn't have anything to say. So I'll let you reserve as much of that 15 as you'd like.
I'll take 3 if you don't mind.
All right, and whenever you're ready, you may begin.
May it please the court, my name is Philip Williamson. I'm counsel for the appellants, Dr. Durrani and Cast. For several years, from the first Butler County complaint through plaintiff's response to our motion for summary judgment, this case was indistinguishable from White versus Durrani. In particular, both Ms. Walls and Ms. White were patients treated and operated on by Dr. Shanti, a physician at Cast, and not by Dr. Durrani. Both settled with Dr. Shanti with no finding of liability, basically in exchange for his testimony against Dr. Durrani. And then they sued Dr. Durrani and Cast on a theory of vicarious liability. The cases were so similar that Ms. Wall's 2-page response to our motion for summary judgment in this case did little more than to say she was adopting by reference the arguments made in White.
And Mr. Williamson, I hate to short circuit you here, but I guess I'm confused as to the focus on summary judgment at this point, because I think what you're saying essentially is that Ms. Walls changed her story or lied, and therefore you should have been granted summary judgment. But I mean, the way the process works is once that gets past summary judgment, because there is a dispute of fact, we have to view the evidence that comes in at trial. So help me out here. Why are we worried about summary judgment?
Well, we're worried about summary judgment because it's one of the 3 places that I think you can reverse the trial court and direct entry of judgment for Dr. Durrani and Cast. If you prefer to start with the trial evidence, I'm happy to do that because that's probably the simplest and most straightforward path for the court. So the jury interrogatories revealed they found for Ms. Walls on her informed consent claim and on the negligence claim, specifically that Dr. Durrani recommended an inappropriate surgery. And that's just incorrect. And not in a, we're weighing competing theories of evidence, but that Ms. Wall's theory of the case, and this is the argument that her counsel presented in closing at trial, is that Dr. Durrani should have recommended a fusion surgery rather than the decompression that Dr. Shanti ultimately performed. The problem is there is absolutely no evidence in the record that Dr. Durrani ever recommended a decompression. We do know, however, that in Ms. Wall's own words, Dr. Durrani always wanted her to get a fusion. It was Ms. Walls who refused to undergo the fusion surgery. So if the jury's theory of the case is Dr. Durrani recommended the wrong surgery, that Ms. Walls should have had a decompression or should have had a fusion rather than a decompression, Dr. Durrani actually offered the correct advice. Ms. Walls is the one who disregarded that advice. Dr. Shanti is the one who performed the surgery. She was his patient. And so there's no negligence on Dr. Durrani's part, which is to say, there is no evidence or act performed by Dr. Durrani that led to Ms. Walls receiving the wrong surgery. And because she was not his patient, and this was not his procedure, it was not one he recommended and not one he performed, he had no duty to obtain her informed consent.
Well, let me ask you about that, because as I walk through her testimony, and I mean, I know this is part of your complaint on a factual matter, but she does blur the lines as to who her doctor was. And she tries to link much of her treatment to Dr. Durrani. So what is your response to that?
While she tries to blur the line between Dr. Durrani and Dr. Shanti, which you're right, is part of our complaint here, she does not blur the line on the advice she received from the 2 physicians. It is absolutely clear throughout her testimony in this case that Dr. Durrani recommended a fusion, that Dr. Shanti agreed with her on more conservative measures and ultimately on a decompression. So for example, if you go to page 1060 of the trial transcript, Ms. Walls says, actually, he, that is Dr. Durrani, recommended a fusion. On page 1102, she says, I think Dr. Shanti agreed with me on more conservative measures. And then on 1256, she says, Dr. Durrani always wanted me to get a fusion. He said the back pain would never go away unless we essentially took that herniated disc out. So while she may blur the lines between over who was her doctor, it is absolutely clear in her testimony, Dr. Durrani recommended a fusion and she did not want it. But if you go to her counsel's closing arguments, it's page 1782, her counsel argues to the jury, Dr. Durrani should have recommended a fusion, which is exactly what he did. I mean, the negligence question is, what should he have done differently? He recommended the right surgery and she didn't want it.
Mr. Williamson, I think was Mr. Williamson frozen for a moment? Mr.
No.
Williamson, oh, all right, I'm sorry. You've got 6 minutes remaining if you want to reserve your 3.
I am happy to get into either of the other reasons why the trial court ought to be reversed. I'm also happy to talk about sort of even if you choose not to reverse the trial court in this case, I think there are several sort of post-judgment issues that need to be cleaned up. So I'm happy to get into any of those if the court is interested, but otherwise I'm perfectly content to shut up and sit down.
Mr. Williamson, could you talk for a little bit about the damage issue and your theory that because there was a 50% split, that the court had to do that after applying the damage cap? Because I had trouble following that from a statutory interpretation perspective. So if you can help me out with that, I appreciate it.
Sure. It's basically this, Your Honor. Ms. Walls could have proceeded against Dr. Durrani, Cast, and Dr. Shanti in the same case and not settled with any of them. She goes to trial, obtains the same verdict, but now it's against 3 parties instead of 2. She still would have been limited to the same $500,000 verdict. What she has done here is by settling with Dr. Shanti for no liability, she has now put that entire verdict on the non-settling defendant. And that's just not how the damage cap statute works. It is a damage cap for the event, for the claim, for the tort, and not a sort of damage cap per defendant or per responsible party.
What do we do if, like, say one of the otherwise defendants is immune? Say it's an employment situation. Well, that doesn't make sense. But there's immunity, or they're just out of the country or something, so they can't be sued as a defendant. How do we deal with that?
Well, Your Honor, I think that case turns out perhaps the same way, because what you're really saying is that either the plaintiff in that situation is getting a windfall because there is a defendant with deep enough pockets, or you're basically letting the escaping defendant get off scot-free, which, Your Honor, it's probably worth pointing out is something that this court has expressed some real discomfort with anyway. In some other
but the plaintiff isn't getting a windfall because they're getting the $500,000, which is their max under the damage cap. So I do hear your point that, like, it's unfair vis-a-vis the defendants, but then I go back to my original question, like, what specific statutory language helps us get to the result that where you want to go?
Sure, Your Honor. It is that and forgive me for not having this right at my fingertips, but that the damage cap statute is not described or defined as a cap per defendant. It is described as a cap for the claim. There's a cap on the damages for the claim. And so regardless of how many defendants Ms. Walls sues, her damages are going to be capped. It's the damages for non-economic loss that is recoverable in a civil action. That is, it's the damage cap applies to the action, no matter how many defendants you sue, no matter how many tortfeasors there are. If it's one action, there is one damage cap. And what Ms. Walls has effectively argued is that she could have gone after each of the defendants seriatim and sort of recovered a separate $500,000 damage per action. And that's just not what the damage cap statute is designed for.
You have about 2 minutes remaining if you'd like to add those on to your reserved time, or keep going with the 2 minutes.
Well, if the court doesn't have any further questions this time, I'll add those 2 minutes to my reserve time, if you don't mind.
All right, thank you. You'll have 5 minutes then. Mr. Winter, you've got 15 minutes.
Judges, thank you. Bob Winter on behalf of the plaintiff appellee. We've taken off on what was the surgery that was supposed to be performed. There was a MRI performed on Ms. Walls by Dr. Shawnee and on behalf of Dr. Shawnee and Durrani on April of 2012, and they went over, both of them went over the MRI results with her on April 19th, 2012, and that's at page 1099. The plan that Dr. Durrani came up with was that Ms. Walls was to undergo a decompression surgery and not a fusion surgery. That's a page.
Well, can you help me with that? Because I thought the evidence was undisputed that he was recommending a fusion surgery and not the decompression surgery.
That's not what Dr. Bloomfield testified to.
But how is Bloomfield's not there? How is are you saying he's a fact witness?
No, he can read the medical records that were placed in front of him and he testified to. What was actually performed was a laminectomy at 3 levels.
Well, no. I know what was performed.
Yes, sir.
But my question is, the jury found that Durrani was liable because he recommended a surgery outside the standard of care. And all the evidence that I see in the transcript and the record is that surgery he recommended was decompression. So what is the record site that shows that fusion. What is the record site that shows that he recommended the decompression?
Page 1102. And Ms. Walls agreed to the decompression. But what actually was performed is something else.
Well, so I'm sorry, on 1102, it would show me that Durrani recommended decompression.
That's what I have in my brief. I didn't check. Yes.
Okay. And I mean, there's no evidence that Dr. Durrani actually performed this surgery on this record, is there?
He was supposedly the number 2 man in the room per the op report.
Well, but supposedly is different than he was there.
That's what the report showed, Judge Bergeron. No, there. Dr. Bloomfield testified as to what goes on in there where there's the lead doctor being the backup man and Dr. Shawnee being the lead doctor. But I don't think there's any complaint that by us that the surgery was improperly performed. It's just the wrong surgery was performed.
But this is this is the struggle I have on causation here. The surgery was performed, but it was performed by Shanti, and you gave up your claims against Shanti. If he performed the wrong surgery, like, he should be on the hook for that. And so what I'm trying to figure out is, how is Durrani on the hook for Shanti's surgery?
Both of them, what showed up was laminectomy at 3 levels. And Shawnee and Durrani are responsible for that.
Well, I understand Shawnee because he is the surgeon. So if he performs the wrong surgery, he's on the hook for that, no question. But the gap here is Durrani's responsibility.
Durrani planned and organized what happened in the operating room. And what happened, he was there, and there were 3 levels of laminectomy done during that procedure. He was there. He could have stopped his employee from performing the wrong procedure.
But that sounds like a vicarious liability theory, and that wasn't what you prevailed on at the end of the day, because the court rejected that.
He was there. He was the number 2 man in that surgery, on that surgery. And thus the jury found what it found. There was a patient-physician relationship. They correctly found that. And the plan was to do decompression, and it didn't occur. The imaging, the MRI, did not support that procedure. And Durrani was there. He saw it. He knew it.
You're saying he
So is
recommended I'm sorry.
I'm sorry, Judge.
We
Excuse
both
me.
started talking at the same time. I'm just trying to understand your argument. You're saying that Dr. Durrani recommended the correct surgery, but then he was there when the incorrect surgery was performed. It didn't stop it.
That's what happened.
Okay.
I mean, she agreed to a decompression. It should have been a decompression, but she got a 3-level laminectomy on the lumbar spine. And
So following up on Judge Krause's question,
Yes,
your
ma'am.
theory is his negligence was failing to intervene as the surgery was being performed.
that's, among other things, yes. Yes.
What other things?
It's what the jury found. He did not stop what was going on that was improper. There just wasn't the stenosis on it. He didn't execute the plan. It should not have been a laminectomy. It should have been a decompression. And the jury got it right.
And you still have 8 minutes remaining if you'd like to use the 8 minutes.
I think we've pretty much, I think the judge got it right. I was on the cap, notwithstanding Mr. Williamson's argument. She was capped under the statute.
Well, let me ask you about that.
Yes, sir.
Because I mean, I part of Mr. Williamson's point is that if you had, let's say, under your theory, 2 surgeons here involved in the surgery, she could then sue each one separately, one after the other, and max out her recovery against each 500,000 and then get $1 million instead of the cap of 500,000. Is that right, or is there something wrong with that?
Well, those aren't the facts before us, but she's capped at 500,000 here. And but she's entitled to one cap of 500.
So you would say that she couldn't do that. She couldn't, if she won the first trial for 500,000, she couldn't then go undertake a second trial against the other doctor and try to get another 500,000.
I believe that's correct.
Okay.
That's correct. I think everything else is in the brief, and I just ask that this court affirm the judgment in this case in favor of Ms. Walls.
Thank you, Mr. Winter. Mr. Williamson, you have 5 minutes remaining.
Your Honors, a couple of quick things. Number one, Judge Bergeron, I think you were right to point out, Dr. Bloomfield knows absolutely nothing about Dr. Durrani's involvement or the relationship between Dr. Shanti and Dr. Durrani. And while it is true that he could read medical records in front of him, reading those medical records, he would have seen the same thing that we argued in our briefs, which is that Dr. Durrani doesn't appear in this case. But more importantly,
didn't Bloomfield indicate, again, for what it's worth, he's not a fact witness, but didn't Bloomfield indicate that Shanti performed the surgery?
He did, but you don't really have to rely on Dr. Bloomfield. You can rely on Dr. Shanti himself, who testified in his deposition, and that's transcript of docket number 232 at pages 35 to 37 and then 45 to 46. Dr. Shanti says he performed the surgery alone. Dr. Shanti is the only man who was in the operating room conscious who could have told you who was in the room. And he says he performed the surgery by himself. So with due respect to Mr. Winter, it is simply not the case, and there is no evidence in the record that Dr. Durrani was in the room and could have stopped the surgery. That's just not there. He wasn't present. Dr. Shanti says he performed the surgery alone.
Well, was he supposed to be present? And would that be negligence if he was supposed to be present? And presumably, if he was, it could have stopped something from going wrong. Is that negligence?
Well, Your Honor, they didn't make that argument at trial. And so I can't really speculate as to whether that would be deemed negligence or not. But on the subject of sort of these alternative theories of negligence, if I heard Mr. Winter right just a moment ago, he suggested that one of the things that the jury found was that Dr. Durrani was negligent for being present in the room and failing to intervene. And that's just not true. I will read for you the jury interrogatory. It's interrogatory number 3 in full. Defendant suggested surgery for Ms. Walls outside the standard of care. That is the negligence finding. Not that Dr. Durrani should have intervened while Ms. Walls' back was open, not that he should have stopped Dr. Shanti from performing the surgery in real time. It is he suggested a surgery outside of the standard of care. And that finding, we know, is not supported by any evidence in the record. We know that whatever Dr. Bloomfield sort of might have hypothesized about the relationship between Durrani and Shanti, Dr. Shanti testified that he was the one, that is he, Dr. Shanti, and not Dr. Durrani, who made, quote, all the major decisions, end quote, about Ms. Walls' care and treatment. This was Dr. Shanti's show from start to finish. There's no evidence that Dr. Durrani recommended a decompression. There's no evidence that he was involved in the surgery. And going back to page 1102, just to tie off one point, Ms. Walls does not testify that Dr. Durrani recommended a decompression on page 1102. What she says is that in her conversations with Durrani and Shanti, they recommended a fusion or decompression surgery. And then she says, Dr. Shanti was more along the lines, he agreed with me on the conservative measures. And Dr. Durrani agreed to try that surgery because I didn't want to do the full out fusion. Which is to say, Dr. Durrani didn't recommend a decompression. He agreed to a decompression because Ms. Walls refused to get the fusion.
Well, and maybe I'm getting tripped up over the medical terminology, but I thought I understood Mr. Winters to say that the problem was that Durrani, maybe consistent with 1102, recommended decompression, but decompression was not the surgery that was actually performed. Is that right, or am I missing something?
And I believe we addressed this in our reply brief in one of the footnotes, that what you have here is tossing around a lot of medical terminology to describe basically two procedures. So laminectomy and decompression are the same surgery. Dr. Bloomfield refers to it as a decompressive laminectomy in his depositions, page 25 through 27. While a discectomy and a fusion are the same procedure, and that would have been removing the herniated disc that was actually causing all of Ms. Wall's problems, and basically sort of fusing a couple of discs together. And we cover that and kind of explain that distinction in footnote 4 in our reply brief. But again, even if, for example, the thought is, maybe someone recommended a laminectomy or recommended a fusion, and that wasn't the right surgery. The one thing we know is that to the extent that Dr. Durrani offered any recommendations to Ms. Walls in this case, it was every time a fusion. In her own words, he always wanted me to get a fusion. In the words of her attorneys, that is precisely the advice she should have been given, and she refused to agree to it. So there's no need to get tripped up on all of the terminology. It's simply, he recommended a fusion. That was the right call, and she did not agree.
And Mr. Williamson, you are at your time.
Thank you, Your Honors.
Counsel, thank you both very much. Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion. Thank you. And Ms. Hayden, if you will bring the next counsel into the courtroom. Good morning, Mr. Herzig.
Morning, Your Honors.
Our next case on the docket this morning is Walls versus Durrani. Mr. Herzig, if you will have 15 minutes to argue.
Sorry, Judge Myers, it's Adams.
Oh, I'm sorry, Mr. Adams, your name on your, thank you.
No. It's Adams versus Durrani.
I'm sorry, Adams versus Durrani. Thank you, Judge Bergeron. Looking at my sheet and looking at the case we just had. Mr. Herzig, you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
I'd like to reserve 3 minutes, Your Honor.
All right, whenever you're ready.
Good morning, Aaron Herzig on behalf of appellants Dr. Durrani and Cast. May it please the court. We are at the beginning still of what will be many appeals of trials related to Dr. Durrani. And I think this is an important case and opportunity for the court to continue setting some rules of the road for the trial courts. So I'd like to focus on 3 of the errors that I think are important in that respect. The first is the question of evidence of revocation of license. The second is the set-off credit issue. And the third is the use of experts. And I think it's important, Your Honors, because what we're seeing as these trials progress is an effort by plaintiffs in these cases to try the person, not the medicine. So many of the errors that are coming your way relate to efforts to try to get into the record evidence that is unrelated to the particular surgery in this case. I think the Walls case that you just heard provides an example of when that becomes problematic, because a jury can even be convinced to blame Dr. Durrani for a surgery that he did not perform. And so I hope this is one of the cases where this court takes the opportunity to set some rules for the road. with regard to revocation of license evidence, this court in Setters did determine that it was unfair, prejudicial error for a trial court to allow evidence of the revocation of Dr. Durrani's license with regard to surgeries that he performed. In that case, the court said it was harmless. We disagree with that view in that case. We frankly think it's very difficult to say that error is ever harmless with regard to a doctor's negligence if the jury is told that the doctor is no longer a doctor and not given the sense then that someone has pulled his license related to that surgery, when of course that isn't true, as this court found in Setters. But in this case, it's really quite different, and I'll explain why in a second. But I think in general, one thing that the court should be aware of is as the trial courts are trying to sort out how to deal with this, some of them look at that harmless error and think to themselves, well, maybe I should admit it, and then it's just harmless. And so I think a strong signal from this court about the fact that revocation of license evidence should never come in is quite important. And this is a really
we gave that strong signal in Setters, and I mean, I as I read the record in this case, you all keep talking about hundreds of references to this, but really that's because people use Mr. rather than Doctor, and I don't see a repeated effort to inject revocation into the trial here. The court gave an opening admonition about that, but I don't see it coming up again during the trial. So what am I missing there?
Your Honor, this is exactly the kind of thing that I think this court needs to give a strong signal on. What you have here, and I'll quote it from our brief, it's at page 407 of the trial transcript. At the very beginning of the case, in voir dire, the judge says, Mr. Durrani is no longer a physician in the state of Ohio. He was a physician licensed when this occurred, but he is not a physician. He then says, the judge says, I'm not going to refer to him as Dr. Durrani. I'm going to refer to him as Mr. Durrani because that's what he is right now. So the judge at the very beginning of the case is telling every potential juror, including those, of course, who end up on the jury, that he's using Mr. because Dr. Durrani is no longer a doctor in his view. Of course, Dr. Durrani is still a doctor in his view by virtue of having graduated from a medical school with a doctorate degree and the fact that he can continue to practice perhaps elsewhere. So it's factually inaccurate. But it also was a signal from the judge at the beginning that Mr. Durrani meant something. And the jury absolutely picked up on it. We reference dozens.
Where specifically did you object to the usage of Mr. Durrani?
So, Your Honor, this is the appellee's raised waiver. The fact is, as this court said in Setters, this is an issue that we raised in pretrial motions under Evidence Rule 103 that is sufficient for raising this issue. We made the point several times, and as this court said in Setters and as Evidence Rule 103 indicates, we don't have to do it every single time it occurs. We believe the error is absolutely preserved here. Unless you think
you all filed a motion in limine on this issue?
It was all part, as you know, in these cases, there have been pretrial motions that cut across many of these issues that were decided by Judge Swikert or others. And in that same context, this issue was decided. So the court having firmly decided it after proper objections from us, the burden is no longer that we have to continually object throughout. And
there were specific objections by you on against the court calling him Mr.
There were specific objections about the revocation of license issue coming in, and the judge specifically tied those two things together. And unless you think it doesn't have any effect, when you look at the interrogatories written by the plaintiffs, when they write out why he was negligent, they write Mr. Durrani was negligent. The jury understood exactly what was going on here. And if the court is at the stage where it's going to try to parse how harmless or harmful this error is in every single case, I would argue, first of all, that's a demonstration of how far the court has to go to bend over backwards to make this error go away. And I don't think that's the business the court should be in these cases. The court needs to clearly define that these are cases about medicine, not the character of the person. That is how our system works. And so I think all of that leads to the idea that this court needs a strong signal, and this is a great case to do it in. It's also, there was no effort to limit that instruction at all. There was never and by the way, you should disregard. None of that exists here. I think the judge was trying to make a point, and I think it's the kind of thing the court should admonish. Unless there are other questions on that topic, I'd like to move on to the set-off and credit issue. This court in Setters did say that there can be set-off and credit. What Appellees will tell you, I think fairly, is that in Setters, the objection wasn't raised in the same way that it was here. So I think you're squarely facing the substantive question, perhaps in a way that you didn't have in Setters.
Well, they conceded in Setters, right?
That's a shorter way of saying what I was trying to say, Your Honor. Thank you. But here we have the same basic idea, and again, I think a place where this court needs to make clear that these courts should be considering set-off and credit from the beginning. Some of them are. Some of that is working its way through the system. But the main argument of Appellees is this isn't the same injury. Well, the complaint says otherwise. Negligence, fraud, those claims are against every single one of the defendants. The plaintiff settled with Westchester Hospital. We haven't been able to
and Mr. Herzig, I mean, one of the things I've struggled with on this question is, like, what if this needs to entail factual finding by the jury, and what if it is just, as a matter of law, and but like, where do we know that these are or are not the same injury? And like, you're pointing to the complaint, but I mean, this is after trial. Why are we worried about the complaint?
Because, Your Honor, the judge post-trial can impose this as just like remitted or that kind of thing. They can using the statutory mechanism of 2307.28, they can set off against that.
But do you have to ask? I mean, do you have to ask for factual findings by the court to determine the propriety of this?
Well, Your Honor, so two things. First, I think you don't necessarily want a jury doing this, because then the jury is learning about settlements with other defendants, and there are serious problems there. But yes, the judge should be making, I think, findings of fact. There should be the opportunity to do discovery. That's a battle that we're having. In fact, Setters is coming back your way to deal with that particular issue in the coming months. And sorry to keep interrupting you, but as I recall, the post-trial motion on this topic, it was really just 2 paragraphs and pretty conclusory. So how was the court supposed to know that it was incumbent upon it to make these findings and kind of go through this entire analysis? So the motion, I think, does the work of telling the court to do that. The court has the evidence of these settlements. So it has what it needs to make that decision. Defendants don't, or plaintiff, we're defendants. Defendants don't at this point have that information, so we can't make we can't make that argument other than we know there's a settlement. We know the allegations and the complaints overlap as to these defendants. So yes, it then becomes incumbent on the court to dig into that. The court, and again, this is coming up. This isn't yet before the court in this case. This will be in front of it when Setters returns. The question of how that discovery works and what we're entitled to is another battle that is being fought right now.
So the issue of the interrogatory that wasn't given, you're saying now that despite the fact that this interrogatory wasn't given, the court still, if we agreed with your position on remand, would have what it needs to figure this all out?
That's a good point, Your Honor. We think there needs to be a new trial with the ability of the court to separate negligence and battery and do a set off for at least the negligence claim. So
So
that's a
the
real
court
challenge.
doesn't have what it needs if there were to be.
Right. Excuse me, Your Honor. Yeah, yes, I was speaking a little bit generally because we have so many of these cases. The typical process right now is that the court does have what it needs. But you're right, in this case, there is actually a further hurdle before we even get to that question, because of we asked for an interrogatory, excuse me, that would have separated the damages for negligence and battery. We didn't get one, so we're not even at that point yet.
Did you even though, looking back over the record, did you explain to the court the significance of that interrogatory, that it was needed because you were going to be asking for a set off later?
I don't know that we raised that particular issue, Your Honor, but we do think it was important, and there are several reasons why it's important to typically get specificity from a jury about where they think there was a battery and where they think there was negligence and which damage was caused by each. So if we didn't articulate every single reason, we still think that we preserved this particular error.
And is there anything in the record that would help us to understand why it was not given?
No, I don't think the court articulated its decision in a way that this court could do. So it's effectively a question for you all at this point. But no, there isn't a great record on why the court made that decision that I recall. I think I'm running close.
You are at your time, Mr. Herzig.
Okay. I will, if I may, at the risk of losing some of my rebuttal, I do think the third important piece here is the use of experts. Here they used a neuroradiologist to discuss what were surgical opinions. The cases that appellees rely on deal with one type of oncologist opining about a different kind of oncology, or in the other case in the Supreme Court, whether a cast was properly put on somebody, which the court at the time said even a technician could do. That's not the same thing. Here we have a radiologist opining about surgical, what a surgeon should opine about. We think it was error to admit it under Rule 702.
I thought he was just testifying to what the scans showed and whether the scans showed that surgery was appropriate. Isn't he qualified to do that?
He is, and we say in the reply that piece of his testimony we don't have trouble with. But he, using the wrong images, he admits during trial, was also opining, and he says so. He's opining on whether the surgery should have been performed or not, and that is outside of his province in our view.
And he was thoroughly cross-examined on all of that, though.
He was. That's right, Your Honor. Our view is that the gatekeeper function failed here. This wasn't a weight of the evidence question. This radiologist should not have been allowed to opine about the appropriate surgery or the surgical outcomes. And with that, I'll reserve whatever is remaining. Thank you, Your Honors.
All right. Mr. Winter, you have 15 minutes.
Thank you, judges. Following on behalf of plaintiff appellee Patricia Adams. With regard to the revocation issue, the judge entered the pretrial order. He also made a statement to the jury consistent with the pretrial order.
Mr. Winter, let me interrupt you then, because in Setter, we said it was improper. In that case, we found it was harmless error because it didn't permeate the record. There were only a few times. Can't it be argued here, though, it did permeate the record? Once the judge, the person with authority, tells the jury, I'm not going to call him Dr. Durrani, I'm going to call him Mr. Durrani because he can't practice medicine in Ohio anymore. Doesn't that really, from then on, isn't that different than Setter?
No.
Why not?
It isn't. I mean, let's just say, for example, Dr. Durrani, Mr. Durrani bothered to show up. What would we call him on the stand? I mean, I'd call him Mr. Durrani.
Well, isn't somebody who graduates from medical school a doctor, whether they're licensed or not?
I would still call him Mr. Mr. is a honorable term.
Well,
But
but
as a
wouldn't it be different though if if you just started doing that and nobody said anything about whether or not he was licensed? If the other side called him doctor, you called him mister, the jury might not pick up on anything and might not read into it revocation. But isn't this different than just calling him mister out of respect?
We did call him Mr. out of respect.
No, I guess my question wasn't clear. If there
Okay.
weren't a statement by the judge at the beginning of trial as to why he was going to call him doctor, and instead just call him mister, and instead just started calling him mister, that wouldn't have brought it to the jury's attention. And it might be fair to say they couldn't read into that he wasn't licensed anymore.
No one said that, discussed the facts and circumstances surrounding his loss of his license. He could have retired, he could have surrendered his
Isn't
license.
that what the problem is though?
No.
Because the loss of his license had nothing to do with the allegations in this case. So the jury's just left to speculate.
I agree. We just, and he made that clear. We're not going to discuss any of those issues. I'm calling him Mr. Durrani. He's not a doctor at the time of the trial. It would be false to call him, in my opinion, Dr. Durrani, because he's not a practicing doctor. But let me pick up on something that I think is really important. You know, you're going to hear a lot of this, try the medicine, not the man, the character. The character was left out, and the jury did pick up on what was going on.
Well, the character wasn't left out. I mean, you guys smuggled it in with Wilkie, even though I don't think they properly preserved objections to it. But I mean, that guy was just, every opportunity he had, it was character assassination.
He had no doubt discussed that the technique used here was, and the decisions leading up to, was improper. He used the word.
Well, but see, I think this is part of my concern is it's one thing to say this technique is improper, this doctor deviated from the standard of care. It's a different thing altogether to use ad hominem attacks, to call him a charlatan, to say he lied. All of that, that's more on the emotion side of the equation, trying to tug at the jurors' emotions than asking them to decide this factual dispute before them.
But okay, well, there were disputes, Judge Bergeron. There was a lumbar spine at issue, and there was a cervical spine at issue. We prevailed in jury interrogatory number 2 on the cervical. We did not on the lumbar. So, you know, use the character assassination, use the medicine. I mean, doctors Bloomfield and Wilkie testified as to the lack of standard of care of Dr. Durrani on the lumbar. The jury found no negligence by Dr. Durrani on the lumbar. They're able to see what's going on here. Notwithstanding him being Mr. Durrani, notwithstanding him being called a charlatan, a liar, even in the worst case scenario, they got it all right. And we tried the medicine, not the man. We prevailed on the C1, C2 procedure. We didn't do so well on the lumbar. It just, you know, this argument that's being made about revocation being a problem, Mr. being a problem, falls apart. If I can go to set off, if I may.
Well, one final question on the
Yes, ma'am.
revocation.
Yes.
Is your argument, in light of Setter, yes, it's improper to mention revocation, but in this case, the error was harmless, just like it was in Setter?
The judge, I don't think that we used the word revocation. There's no board, there was no revocation. I didn't see any citation 2, the Durrani medical license was revoked.
So in this case, you're arguing that just referring to the inability to practice medicine in Ohio isn't the same as evidence regarding revocation.
Correct.
All right, thank you.
Correct. Yes, ma'am. Anything else I need to cover? Thank you, judges. With regard to set off, Judge Krause, you hit it on the head where we did not, we conceded the set off argument in setters. Here we do not. In this case, what was settled with Westchester, as we will see, is negligent credentialing claim, which is, we all know, the claim held by a patient for a hospital's negligently credentialing an incompetent physician. That's not, as we've argued from time to time, not medical malpractice. And in order to have a set off, the parties must be joint tortfeasors. And I've cited the Clevicon case 90 Ohio App 3rd at 215.
Well, and Mr. Ron, this ties back to my questions to Mr. Herzig, but procedurally, how are those determinations supposed to be made? Are these questions that should go to the jury? Is there supposed to be post-judgment fact-finding by the court? I'm just a little confused procedurally on how we sort this out.
You know, when we got around to doing this, that issue was kicked around. I mean, I think it needs to be done to performed to the jury. They're the ones that heard the evidence. They need to make the call. I mean,
you all objected to the interrogatory.
I'm sorry.
You all objected to the interrogatory that they requested.
Well, we've had some time to think about it. That the jury needs to decide it.
So you think in the future there should be such an interrogatory given?
Yeah, I think so. They need to they need to decide whether there should be a set off or not. In this case, we aren't joint tortfeasors. I forgot which district it is.
Well, but I just want to understand that a little bit better, because like if you've got a trial against Durrani and the allegation, their claim is there should be set off against Westchester or Christ or whoever, then like you as the plaintiff would want them to be able to kind of use another actor and kind of bring in testimony about that and deflect attention on their client?
No.
Well, I mean, that's what they would do.
Yeah, that's right. Now that you got the thinking juices stirring on me, Judge Bergeron, you're correct. You're correct. But in this, we don't want to deflect from the medical malpractice case, because that's what this case is. I mean, and after all, in these type of cases, there's where we do have negligent credentialing being tried. Those are bifurcated issues, so we don't want to confuse those issues.
Well, if this case were remanded to determine set off, does the trial court below have what it needs to even make that determination?
Well, do I get to say it doesn't have to go back? Assuming
well, yeah, I know that's what your position is. I'm just
okay. I think what's happened is that the amount of the settlements under seal, that amount is dealt with. How do we do that in setters? But I believe the information is getting to the court and to defense counsel. And then we generally settle it from there or go for it. In the process, we haven't settled anything. I see Mr. Herzig shaking his head. That's true. But the information would need to be had if, in fact, we get past the joint tortfeasors issue. And,
Isn't it just as simple as the trial court getting the information it needs as to dollar amount and then as a matter of law, setting it off?
I'm sorry, Judge, please try me again.
Yes. Isn't it as simple as just getting the court information it needs in camera as to what the amount of the settlement was, assuming, put aside the assault and battery issue, and then just having the judge set it off?
That's one way to resolve it, yes. That'd be one way to resolve it. But I don't think we get there, but also Judge Barrett and Atwood followed the Court of Appeals case and found against Durrani and Cast on a set-off issue in the Atwood versus UC Health case.
You have about 2 minutes left, Mr. Winter.
Well, that's pretty good. Good. As far as experts go, I think doctors, their neuroradiologist, Dr. Marks and Dr. Sayani testified contrary, surprise, surprise, on what the imaging would show and whether it supported or didn't support the surgery. I don't think there's any doubt that the ultimate decision maker is the surgeon who decides to make the surgery, but the neuroradiologist provides his or her input and as to whether it is appropriate to do a certain surgery given a certain state of affairs on the imaging. And Dr. Sayani felt that the surgery was inappropriate. Both surgeries were inappropriate, excuse me, and he testified accordingly. He didn't, I think the gatekeeper function performed well, and we have good results. We have the lumbar going for Dr. Durrani and the cervical going for Ms. Adams. The jury wasn't confused. So with that, I would ask that you affirm the decisions of the jury and trial court and affirm.
Thank you, Mr. Winter. Mr. Herzig, you have 3 minutes remaining.
Thank you, Your Honor. I'd like to focus on you've asked a lot about the procedure with regard to set off. I will say, just as you're thinking about the implications of this case for other cases, that when you remanded setters for this question, the trial court then created a procedure, and that procedure is what is now coming back to you on appeal. So there will be an opportunity to deal with that with better facts in front of you. I think right now what you have, as Judge Krause pointed out, is a first hurdle, which is that we should have had an interrogatory separating negligence and battery so that we could then properly address this. What I think the correct procedure should be, and there are problems with this, is that to Judge Meyer's point, there is something mechanical about what goes on here. Now, Mr. Winter continues to talk about joint tortfeasor and how Judge Barrett dealt with it in Atwood in the Clevicon case. That's all outdated. That's a prior version of 2307.28. What we now talk about is whether it was the same injury, whether the settlement was for the same injury as what the defendants here were found liable for. So the judge would need information from the settlement to determine what claims were settled. And that actually could affect intentional torts too, because you would get into questions of whether they admitted liability or not. Most settlements don't, but you never know. And so
how would that work if there were no litigation? So I send a demand letter and say your client did these bad things. We want payment, and your client agrees to that and settles it. So we don't have a complaint that sketches out the basic details. What do we do in that situation?
So that's not one that we have here, obviously, but I think that then the judge might have to do some fact finding about whether it was the same injuries, and you would look to the settlement documents. And one of the challenges that you're going to hear about in the Setters case is that The hospitals, I think, appropriately raised concerns about the confidentiality of their settlements. The court right now is dealing with that by simply looking at the documents, him or herself, and not allowing defendants to have the information we need to challenge that. It's really, you're going to hear a due process issue coming your way. And we think we can do that without violating or infringing on the hospital's confidentiality concerns. But yes, there has to be the opportunity for all parties to see the evidence upon which the judge would determine set off, have an argument about that, and then the judge makes a determination. Was it the same injury? And if so, how much was settled, and set that off against this particular claim. So that's how I think it should work. I would suggest to the court that trying to wrestle with that now, when it's coming up to you in a better formed way in setters, it's something for you to think about. And you do have that primary hurdle. And I'm guessing I have used all 3 of my minutes on that.
You have. Thank you very much, Mr. Herzig. Mr.
Thank you,
Winter, Mr. Winter, Mr. Herzig, thank you for your arguments this morning. That will conclude this case. We will take it under submission, give you a timely written opinion. And for the next case, Ms.